Hi everyone. So my name is welcome to common legal issues that impact game developers or legal pitfalls of game developers. So my name is Andrew Thomas. I'm an associate attorney at Premack Rogers Downs. We specialize in video games and entertainment. We represent developers, publishers, content creators, film production. We kind of do it all. And we help them with their from starting to their contract needs to navigating complex legal issues that might crop up. Quick legal disclaimer: I before we begin, I am not your attorney, and no attorney-client relationship is formed by attending this presentation. Everything in this presentation is legal education and not intended to be legal advice. If you do have an actual legal issue, then please reach out to a lawyer after the presentation. And if you can frame your questions as hypotheticals, that would be great. So what we will be covering today is four basic areas: business formation, contracts, intellectual property, and at the end, privacy. If we run a little long, I may skip privacy, but we'll try to get there. These are kind of the four basic areas that I feel most game developers should be aware of, and that get most game developers into trouble, and are the questions that usually come up when game developers come to us for legal help. So the first area is business formation, and why you should form a business entity. Well, the first reason to form a business entity is for what's known as limited liability. And what limited liability means is that the business is liable for any debt or other liabilities instead of your own personal assets. For example, if the company takes out a business loan, then the company is liable for that debt, not you personally. Similarly, if someone sues you for copyright infringement, then the company is liable for the settlement or for the verdict, not you personally. So if you do end up in a legal dispute, they can't necessarily come after your house. Now, I should caution here that this isn't a foolproof. So the limited liability can be pierced. It's you'll hear a term as piercing the corporate veil, and this is when you commingle assets, or you're using the business really as a front for your own personal ventures. But if you're running the business correctly, then you should have limited liability. Now, the next reason why you would want to form a business entity is it's a good way to centralize ownership of all the IP. As we'll discuss later on, intellectual property is very important, and it can be very difficult to protect or build the IP if the ownership is spread across many different people. And having a central location, such as a business entity, really helps make that ownership issue much easier. Business entities also receive tax benefits that individuals do not. I am not a tax attorney or an accountant, so my understanding of those benefits is very limited. And it really, so please consult with a tax attorney or an accountant if you want to know more about those. Finally, for business entities are a really great way of sharing ownership and profits. If you're entering into a situation where you need to split profits among many different people or different companies, then forming a business entity together can be a great way to do that, instead of entering into a bunch of complex contracts that then you have to figure out how everything works. So there are two types of business entities that really most people will consider, and that's an LLC or a corporation. There are other types of business entities, such as a partnership or sole proprietorship. But those entities, a partnership and a sole proprietorship, they do not have the limited liability. LLCs and corporations do have limited liability, and that is why you tend to go for those instead of operating as a sole proprietor. So when you're choosing between an LLC and a corporation, there are a lot of differences. There are some similarities, but the main difference is that an LLC is a lot more flexible in terms of how they are set up and operated. You do not need a board of directors, and you can choose how you are taxed. And what I mean by that is that you can either choose to be taxed as a pass-through entity, or you can choose to be taxed as a corporation. And that can be really valuable, especially when you're starting out early on, because generally you'll want to probably be taxed as a pass-through entity instead of as a corporation. However, the downsides to a limited LLC is that it has limited growth potential, because once it is formed, it becomes more difficult to add new members, such as like if you're trying to add new investors. LLCs can also not go public, meaning they can't be traded on a stock exchange. LLCs are also not necessarily recognized internationally, so if you have global ambitions, you might have to think about doing a corporation instead. Corporations, on the other hand, are very strict in their regulations in terms of how they are created and operated. Corporations are required to have a board of directors and to attend board meetings. These are strict regulations that a corporation has to abide by. Also, corporations are locked into being taxed as a corporation, so at the corporate rate. But they do have higher growth potential. They can easily take on new investors. They can go public, and then they are recognized internationally. Generally speaking, I would say that LLCs are probably better when you're early on, because they allow for you to quickly form and to quickly manage, and then you can transition into a corporation down the line if you feel like that the situation has changed. So it is, don't feel like you will get stuck if you choose one or the other. There's always kind of a way to shift depending on the situation. Though I would say that it's slightly more difficult to go from a corporation to an LLC. The IRS doesn't really like that. The IRS, they want to get their taxes, so they generally frown upon corporations trying to become LLCs. So the next area we're going to talk about is contracts. And we're going to start with copyright assignments. And where this will typically come up is in independent contractor agreements or employee agreements. So we're going to quickly cover some basic copyright law so that we can further understand why this is important in a contract setting. So under copyright law, when a work is created, it is automatically granted to the author, with one exception, which I'll get into in a minute. The Copyright Act also requires that any assignment or transfer of ownership be memorialized in a written contract signed by the parties. So what this means is, if you are running a company and you hire somebody to compose music for your game, the company needs a written agreement signed by the composer or the creator of the music to assign that music's IP to the company. Without that written assignment, the composer still owns the copyright to the music. You could pay them, and they would still, if you don't have that written agreement, they would still own it. You have to have that written agreement. It does not matter if you pay them. And that is a very common pitfall that a lot of developers and just artists fall into is that they think just because they're paying, a commission for somebody to create something, that it automatically transfers the ownership. That is not the case. It needs to be in writing and signed by at least the author. This is why basically a good independent contractor agreement will have a copyright assignment clause within it. Generally, be called an IP assignment, but you want to have that in there, because if you don't, then you're not going to have ownership, and that might make it more difficult down the line in terms of selling the game to a publisher, or acquiring a publishing deal, or if the game blows up, then that person can ask for more money, and it can become a really tricky situation. Now, I did mention that there was one exception to the earlier rule, that it has to be a written agreement. And this is what's known as the work made for hire doctrine. And I'm sure if anybody has worked in the industry for long enough, they've probably heard of work made for hire. So work made for hire comes from the Copyright Act. And this is when the law treats the company as the author instead of the human. And this is the only instance where this applies, where a non-human is considered the author. Work made for hire applies in two situations: full-time employees and independent contractor. However, the way it is applied is vastly different and can be a bit confusing. So for full-time employees, you technically do not need a written assignment, and this is the one exception that I mentioned. By law, the work is automatically transferred to the employer if it's from a full-time employee. However, the work has to be created within the scope of the employment. So a 3D artist at EA or Blizzard that's making 3D art, as part of their job, that would be covered. A janitor at EA who's making a game on the side, that would not count. That would not be automatically transferred. Even still, most companies, even with this law, do still have a written assignment in their contracts. So the other situation where work made for hire applies is independent contractors or commissions. And for an independent contractor, they do require a written assignment. And under work made for hire doctrine, you actually have to specifically say that the artwork is a work made for hire. The agreement also has to be signed prior to any work being created. It is very difficult to retroactively make a piece of art a work made for hire. And in that instance, you would need to get a simple assignment instead. So generally, most companies want a work made for hire. And part of the reason why they want a work made for hire is there is there's a different law that called Section 203, which affords authors the right to terminate previous agreements, such as assignments or licenses, and get their ownership back. And the only exception to that rule is a work made for hire. Under work made for hire, as stated earlier, the company is treated as the author, so therefore, the company isn't afforded that right. Overall, the best practice is to just generally have an IP assignment with work made for hire language in it, and then it doesn't apply to if work made for hire doesn't apply, then you have just a simple assignment as a backup. So the next type of contract that a lot of video game developers probably interact with, and probably one that most video game developers are very eager to interact with, is a publishing agreement. Publishing agreements are complex. They deal with a lot. and but you should also understand publishing agreements are one of the few areas where I would say you should hire a lawyer. If somebody's coming to you with a publishing agreement, go out, spend the money to get a lawyer, because a publisher is not going to look after your interest. Do not assume that the publisher is giving you a fair deal. There are some good publishers out there. There are some definitely bad publishers out there. But these are just the elements. So I have up here on this slide listed what I would consider the basic elements of a publishing agreement. And as you can see, there is a lot. And a lot of these may not be familiar to most developers. And it is important to understand how each of these work and how they work with each other. So while we don't have time to go over every element, I am going to hit some key points. The first key area of a publishing agreement is the IP rights. Just as it was for the independent contractor agreement and making sure you have those rights, it's just as important in the publishing agreement. Are you assigning the IP rights? Are you licensing the IP rights? A developer may try to push, or a developer will probably want to retain IP ownership. So that means you're probably going to give a license to a publisher. What does that license look like? Is it an exclusive license? Non-exclusive? Is it go worldwide? Is it only for like distribution in the United States? How is that license structured? Those are all things to consider when you're dealing with a publishing agreement. The second area is payments, and not just you think of payments as, oh, I'm being going to get a lump sum or some amount. Generally, in publishing agreements, they're a lot more complex. And you are going to want to be paid for your work. Generally, a lot of publishing agreements are structured so that the publisher is going to pay out royalties to you. But if they pay you in advance, then they might want to recoup that advance. So they might structure the royalties so that they get 100% of the royalties until they make back the money that they paid you in the advance. Is that fair? Maybe, depending on the context. You might want to push back against that. You might want to say, hey, the majority of the sales of the game happen within, the initial sale period. We would like a portion of that, at least, so that we can keep our doors open. As part of payments is also auditing. You want to make sure that they're being honest about how much they're paying you. There's a term called Hollywood accounting. Hollywood accounting is when publishers and film studios, I'll be blunt, cook the books a little and make it so that a game or a movie does not look profitable, and therefore they don't have to pay out royalties. This happens a lot in terms of when you're dealing with net revenue. Net revenue is at the revenue that's you get after they apply all the expenses. So how you define what net revenue is very important, because net revenue can include every expense under the sun, or it can just include a certain number of expenses. And the way auditing works is auditing allows you to look at the publisher's books and to see if they're being honest about how many games are being sold, what expenses are being applied, and how much money is being owed to you as the developer. Auditing provisions are very important, and if if you don't see one in there, that might be a bit of a red flag. And the chat brings up a good point that everything in a contract is negotiable. You might not get everything you want, but you should ask for everything you need. If if they won't negotiate, that might be a warning sign. It's just, it depends on the context of and how much leverage you have, and what is and what the publisher is offering you. But that you shouldn't be afraid of asking. That is a big thing that I think a lot of new people to contract negotiation, they feel very timid. They're like, oh my god, I got in with this big publisher, and they don't want to upset them. And don't worry about that. They get pushback all the time. So the next area to also be aware of is milestones. Laying out clear milestones can be critical to the success of the game being delivered, as well as the game being published. You want to make sure that you know what's expected of you as a developer, what's expected of the publisher, who's going to do what at one time period, what you're going to deliver, and then what happens when you miss those milestones. You're going to miss milestones sometimes. That just happens, and sometimes it's not in your control. And having it clearly laid out, well, it's like, well, if we miss the milestone, then the parties come together and renegotiate, or one party can walk away. It's important to understand what those contractual obligations are and what the consequences of them are. And leading into that is also talking about what the publisher's duties are. Understanding what the publisher is going to give you. Are they going to give you marketing, resources, QA, localization? What are they going to be handling? What tasks are you going to be offloading? A lot of times QA is a huge endeavor, and it would be good to have the publisher handle that. But also understand that what duties the publisher is going to give you, what services they're going to provide, is also going to affect other areas, such as like the payment. How much royalties are they going to expect? The more services they provide, the more likely they're going to ask for more in royalties. The less services they provide, you can potentially be like, no, I'm not going to give you so much in royalties. Understanding what you're going to get is really important, because this isn't just about them publishing it. It's about what services they're going to provide to you, how they're going to boost your game, and how you're going to, and then what your obligations are too. The next area that a lot of times gets overlooked is what happens if a publisher or developer goes bankrupt or gets acquired. If the publisher gets acquired, is the developer forced to work with the buyer, or can the developer terminate the contract? What happens if the developer goes bankrupt? Does the publisher acquire the IP, or can somebody else acquire the IP? Those are no one wants to think about those situations because they're kind of dark, but those are situations that you should consider because of how they could impact your game. No one wants to go bankrupt, but it does happen. Licensing rights for sequels, ports, merchandising, movie rights, that's another key area that can be, you can do a whole talk on how to handle that. What does it mean to have derivative rights? Does the publisher have the right of first refusal, meaning that if you're going to develop a sequel, does the publisher get the right to say they'll publish it before anybody else? Those aren't necessarily, having too broad of rights in that area can be a bit of a red flag. If a publisher has the right to publish this IP indefinitely, every sequel at the same rate, and at the same terms, that's might not be a fair deal, because yeah, the first game might not be successful, but then you do a sequel and the sequel blows up. And now all of a sudden you're like publishing under this really unfair deal. Not just because this deal is fair for this game does not mean it's going to be fair for future games. So understanding how this contract is going to impact future products, future games, future projects is really important to understand. And finally, the last area you should always look at, and I always look at, is who can kill the project, who can terminate this agreement. If can the publisher just terminate this agreement unilaterally without reason? Can you do that? Are you only allowed to do it if they breach contract? What does that mean? Is there a cure period? Termination and who can kill the project is really important because it can get you out of a lot of sticky situations. If you can end a bad contract really easily, then there's no sweat off your back. But if you are unable to terminate that agreement and it's completely discretionary on the publisher, then that can be you can be kind of locked in a really bad deal. So I've touched on it several times, but intellectual property rights is the kind of next area we're going to talk about. For video game developers, there's really two main IP rights to consider: copyrights and trademarks. There are other IP rights that you should be aware of, but they're not the core. They're not going to be at the core of what you're doing as an indie developer or even a somewhat bigger developer. There's patents. So in terms of other rights, you have patents, right of publicity, and trade secrets. Patents cover inventions and can be very powerful tools, but I should say patents are very expensive and time-consuming to acquire. Just to give you a rough estimate, just filing for a patent, and this is just the filing, not the acquiring, can be around $20,000 in legal fees. It can take up to 3 to 4 years to acquire that patent, and in total, it can run you between $50,000 to $60,000. Generally, patents are useful if you're developing really new technology, and you need to monopolize that. But if you are dealing more artistically, patents aren't. I wouldn't really focus on patents. Right of publicity is the right to use a person's name, image, or likeness. So if you like a famous actor in your video game, or you like a content creator to promote your game, you're going to need to get a license for their right of publicity. This is also known as NIL. So when you hear like the news talk about like athletes NIL, they're referring to their right of publicity. Trade secrets are laws that protect secrets. Coke's secret recipe, Google's search algorithm. Those are trade secrets. Trade secrets last for as long as the secret remains a secret. It's really that simple. And trade secrets are mainly a form of contract law. And you'll usually be protecting trade secrets with NDAs, confidentiality agreements, and some other like protective measures. So copyright is the main IP protection for video games. Copyright protects artistic expression. Copyright does not protect abstract ideas or functionality. So specifically in video games, copyrights does not protect game mechanics. Game mechanics would actually fall under patents, maybe, but generally copyright does not protect game mechanics. Copyright protection is granted as soon as the work is created. You do not need to register your work with the Copyright Office to get protection, but you should. You actually should register your work, mainly because registration gets you access to the courts, and it gets you statutory damages. And statutory damages are a special type of damages that you can recover. and you can only get those if you register the work with the Copyright Office. Copyright lasts for the life of the author plus 70 years. For work made for hire, there are two rules. Protection either lasts for 95 years from first publication or 120 years from creation. And it is whichever one ends first, that rule applies. The reason why there are two rules is because Congress was worried about companies hiding copyrighted work in a desk drawer and then pulling it out and being like, look, we have this. It's going to last for another 100 years. So they wanted to make sure they didn't want companies just to sit on copyright. So what is copyright infringement? Copyright infringement is when a defendant's work is substantially similar to a plaintiff's copyright. So in practice, what this basically means is that a court will look at both works and determine if they believe there is enough similarities. And the similarities have to be of copyrightable material. It can't just be of non-copyrightable material as well. So because people are allowed to copy non-protected elements, such as abstract ideas. So if you're allowed to, so long as it's not, protected under other IP law, you're allowed to take a game mechanic. The idea of rolling dice, that is not, protected under copyright law. So a good example of this is a recent case involving the Nike Air Jordan logo. So Nike based the logo off of the Jumpman photograph. So the Jumpman photograph is the top one, and the Nike logo is the bottom one. And if you look at it, they look very similar. Really, I mean, almost identical. You could say. However, the Ninth Circuit ruled that Nike did not infringe the photo because what Nike took was only the pose. And a human pose, is not copyrightable. So even though it's a bit of a unique pose, because it is a human pose, that's not copyrightable. That's not protectable. So Nike was not infringing just because they took the outline of that pose. So when you're looking to, if you do believe somebody has infringed your material, then there are a couple of tools that you can utilize to protect your work. So you can start with like a cease and desist letter, tell the person, hey, cut it out. If that doesn't work, if they've published it online, then you can send a DMCA takedown notice. I know the DMCA gets a lot of heat about how it applies. But it is a good tool if you have somebody infringing your work, because companies are legally required to comply with it. And then the final option is litigation. Litigation is very expensive. That is not usually that is if you cannot come to an agreement, then we are going to sue you. So I had briefly touched on authorship earlier, but I do think it's an important point, especially nowadays, to kind of reiterate what authorship means within copyright. So in the United States, only a human can be an author for the purposes of copyright, except for work made for hire, where the company is considered the author. Barring that, an author of a copyright has to be human. So an example of this is a recent case called Naruto versus David Slater, which is colloquially named as the monkey selfie case. It is personally a favorite of mine. I love the monkey selfie case. So basically what happens is the monkey steals a camera from a photographer. I actually think he left the cameras to be stolen, but the monkey takes the camera, goes up into the trees, takes pictures of himself. This is actually one of the pictures. The photographer takes those pictures, starts to sell them in a book. PETA sues on behalf of the monkey, claiming that the photographer is violating the monkey's copyright. The photographer claims it's his copyright since he was the owner of the camera. And what the Ninth Circuit said was no one owns the copyright. The monkey was the author of the copyright because the monkey was the one that took the picture. Owning equipment does not give you the right to be the author. The author is the person who actually makes the work. The person who is making the choice of taking that picture at that time. That's the author. So in this context, the monkey was the author. However, monkeys cannot utilize copyright. And since the monkey cannot utilize the copyright and cannot express those and transfer those rights, therefore the rights fall into the public domain. Now, why am I mentioning this? Because this is relevant for generative AI. Because the same logic applies to generative AI, or at least according to the Copyright Office, the same logic is applying. Which is to say that generative AI is not human. Any of that output is not copyrightable because it is not a human creating it. You might have some ownership over the prompts that you put in, but what the generative AI produces is not copyrightable. And the reason why this is important is because if you are implementing generative AI elements into your game, you're at risk of having non-copyrightable material. So the example I always use is, if you need to populate trees within your game and you're not really caring about the artistic style of the design of those trees, then utilizing generative AI might be okay. Because if somebody was to steal those designs, you might not necessarily care. However, if you want to design your main character, the way the main character is going to look using AI, that might be a bit of a problem. Just think about if Nintendo couldn't enforce Mario, or if Nintendo or Disney couldn't enforce the design of Mickey Mouse. Like, that's a huge commercial loss, and can be very detrimental to you capitalizing on that IP. Now, I should say, it doesn't mean that you can't utilize those designs. You just can't stop other people from utilizing those designs. In terms of generative AI, there have been some recent case development. The law is kind of changing on this area. What I was talking about was specifically towards the output of generative AI. There's a lot of conversation in terms of how AI is trained, and there's a lot of cases. So I'm not really going to get into that. I would be happy to answer questions regarding it. But in terms of how you think about implementing AI into your workflow, just know that the output, as the law currently stands, the output would not be copyrightable. So I'm getting short on time. So the next area I'm going to quickly cover is trademarks, and why you should think about trademarks and when you should think about trademarks. Trademarks protect brands, logos, taglines. They basically protect, the marketization of your goods and services. So the technical term is trademark is anything that indicates the source of a good or a service. So a company can have many different trademarks. The company name, the logo, the title of the game, the logo for a game, all could be potentially trademarked. How do you get a trademark? Well, there are two types of trademarks. There's common law and federal. Common law is basically, as soon as you start using it, at the name, like if you start using the name of the game within commerce, selling the game, that is technically common law. However, it is generally recommended that you apply for federal trademark. And you do that through registering the mark with the USPTO. The USPTO will examine the mark to determine if it meets the requirements. And once approved, then you can continue using it. Usually you need to show that the mark is being used in interstate commerce, and that means that basically you're selling your good or service across state lines. You don't have, if you register for a mark, you can do what's known as an intent to use, and that means, hey, I'm not selling this product or this service right now, but I'm intending to do that. And by the time registration comes around, then I am using it and I can prove it. But you do have to show that you're using the mark in commerce. So it's a bit of a lot of people, they worry about like, oh, should I be using the name? Yeah, you should, because it's in commerce. However, do searches and check to see if it's being used, because you don't want to get what's known into trademark infringement. Trademark infringement is basically, is there going to be a likelihood of confusion between two uses of the mark? Technically, you can have two people using the same trademark, but in different, so long as there's not a likelihood of there to be confusion. Likelihood of confusion is, basically, will a consumer believe that these two different goods are coming from the same source? So, here, this would, again, I use the Air Jordan. You can make the argument that there would be a likelihood of confusion. Now, you can also make the argument that there wouldn't, because, like, it's just such a blatant ripoff that most people would be like, it's a ripoff. But I think that Air Jordan would win on there's a likelihood of confusion. In terms of protecting trademarks, it is a bit of a use it or lose it IP, meaning that if you do not enforce your trademark, you may not be able to enforce it down the line. That is why a lot of companies are very aggressive about trademark infringement. And the three main tools are very similar to copyrights, cease and desist, takedown notices, and then finally litigation. And unfortunately, I didn't really have time to get into privacy, but definitely think about it if it because it is definitely an area that is often overlooked, especially in terms of how it impacts you as a company. So with that, thank you so much. If anyone has any questions, feel free to ask in the chats, and I will answer them.
Thank you very much, Andrew. Oh, yeah, there we go. Most important slide.
Exactly.
Really appreciate all that great information. Invaluable stuff there. And again, I mean, we could do a whole nother session on all the mistakes game devs have made and the hassle, pain, and money it has cost them when making their contracts. So definitely great to see the problems avoided before they happen. We're going to turn Q&A over to the folks in our Discord first. So if any of you have questions, feel free to unmute and ask. Andrew's offered to talk about a pretty broad range, so don't hesitate. I know that Destiny might have some questions about the risk we're taking on by having other people's games in our Discord server, but since it's not a monetized thing, we've reduced some risk that way. But I'll let anyone in the Discord answer first. We had a question in from Twitch, which is, if I've signed a work for hire contract, can I use my art in my portfolio?
So this is a question that comes up a lot. Technically, no, because you have assigned the ownership over. However, what you can do is you can negotiate a license back, and this is a very common practice. So you say, okay, I'm going to assign you, or I'm turning over all the rights and ownership to you. However, you're going to give me a perpetual license to utilize this work within my portfolio. The other thing to be aware of is making sure that works with the whatever NDA is also you also sign, and whatever confidentiality, so that you don't accidentally by including work into your portfolio violate the confidentiality. Yes, you can do it, but you have to negotiate that in. If you don't negotiate that in, then technically, no, you cannot. You would have to then get another license from the employer, basically.
And please note that this is true for music, narrative design, etc. If you're a
Yeah.
musician, don't be afraid to ask for the right to play your own music somewhere else. Make sure you can play it live if that's a concern for you. And something we've done at HDI is we've actually given the musician soundtrack rights. So we get the first exclusive use in a video game, but then they can release it as standalone soundtracks. And that's worked
Yeah,
out well.
and that is a very common practice. So it is. I think most companies would be willing to allow you to utilize it to promote for basically self promotion, whether it be just art or music, because in a sense everyone understands that, like, if you work on this big game and you're in it, it helps the game if you are able to promote it, and by saying, hey, look, my work is in here, but also, like, it raises your profile. So but it is something you have to negotiate.
Also in Twitch, Regatta's Con Adventures has a comment that brings up a question. So yeah, basically about common copyright law. That was good to know. But common copyright law, yeah, it's good to have that. But filing copyrights is not difficult. It's good to have a lawyer, especially if you've never done it before. But Andrew, do you mind talking about how easy it is for folks if they need to register? How it's done?
It is really easy, and the Copyright Office is pretty helpful in helping you register it. There are some tricky areas, but basically you can go to the Copyright Office website, and they will walk you through, what they need to register, and then the filing fee is, I want to say, like $80, which is significantly less than a lot of other IPs. Like for patents, we're talking like over $1,000. For trademarks, depending on how many classes you want to register, it's $350 per class. So $80 for registering your copyright is fairly good. And there are, if you have a lot of copyrights, there is also like ways to like bundle them together. I would say it just as a make sure that you have a good understanding of who are the authors of the copyright, because that is an area that can trip people up, that I've seen, where they're like get into tricky scenarios where it's like you have multiple authors and maybe one author died, and how do you correctly do that? So just make sure that you have all your ducks lined up, and then it's a pretty streamlined process.
Yeah, excellent information. And if you do it yourself, I mean, often good to get a lawyer to do it if you've never done it. But also, if your game starts being successful and you've already done a filing yourself, you can get a lawyer to go back and make it firmer and more categories, etc.
I should also clarify that, because I did mention that in order to get into the courts, you have to register your copyright. So it might seem a bit confusing. I also said that copyrights, the protection starts as soon as the work is created, and that is true. So if you create a copyright, then you have protection over it as soon as you create it. So if somebody starts to infringe it after you've created it, you are allowed to then go register the work and then file for a lawsuit. Where it impacts you is the type of damages that you're allowed to recover. So I had mentioned that once you register it, you're allowed to get statutory damages. But before you register it, you're only allowed to recover actual damages, meaning that you have to show like how much they made off of it, how much, and that's what you're entitled to get. Whereas statutory can be like, I want to say it's like 10,000 per infringement. I have to double check on that, but it's like it's like a set amount per infringement that you're allowed to collect. So there are you don't need to register right away. In terms of priorities, I would say there are forming a business, making sure you have your trademarks locked down. Those are higher priorities than necessarily registering your copyright. But if you have somebody that is like infringing your work, then you should definitely go register your copyright as soon as you can.
Great advice. Great advice. And Regattas, I know your game's pretty good. You showed it well at MomoCon. You can share a link for it in Twitch if you want. But also, if you haven't registered it, please do. And you can reach out to Andrew, another lawyer, to file it for you. That's one of the least expensive things you can get a lawyer to do for you. Again, Discord, you're welcome to ask if there are other folks in Twitch or YouTube with questions. Please go ahead and ask. I had a comment I wanted to share and get Andrew's input on. So we talked about IP in the sense of the intellectual property, the game itself, the name of the game, etc. But I know a number of folks in here have also done licensed work as well as contract work. And obviously, you're not going to claim the IP when you're working on someone else's intellectual property. But if you're providing an engine or tools and the like, you can keep your engine and give them a perpetual license to use it in the game. And this has been especially important in Unity, I've seen recently, where folks have signed away Unity development they've done that could be sold on the asset store. So if you're creating something for someone else's IP, you might want to go ahead and make sure that you can keep it and license them just perpetual use for it, or at least license it back so you can use it in your own games. Any thoughts on that, Andrew?
Yeah, so a lot of thoughts actually. So a common misconception in terms of how copyright works is that it's how ownership kind of flows. And what I mean by that is, so if you illegally create a derivative work of a copyright, the original copyright owner doesn't own the derivative. You, as the author, still own it, even though it's illegally made. All the original copyright owner can do is block you from, basically selling it or performing it. But they can't transfer the ownership. They would still have to buy or get you to assign the ownership over. So, and when you start working with other copyrighted things, what happens is it becomes this kind of very complex layered of who owns what, because if you build off of another copyright, whether legally or illegally, you own what you build. And so you have to be very careful about how if you're assigning those rights or not. A lot, when you're like dealing with like things like Unity or other platforms that allow you to build off of them, they will have ways within their contract to kind of either you give them a license or they kind of force you to assign it. You see that a lot in like terms of services. A classic example is Blizzard lost out to the MOBA craze. They lost billions of dollars because when they published World of Warcraft, Warcraft 3, and the modders made the first MOBAs, in their terms of service, they allowed the modders to retain ownership over whatever they created. And they didn't put it in the terms of service that ownership got transferred. And because of that, Dota and League of Legends, all those MOBAs got created and made billions of dollars, while they got, they didn't see a cent of that. What to keep in mind is basically like make sure you go through, like if you're using Unity, if you're using Fortnite, go through, really make sure you understand what um, they're granting you and what they allow you to do. Are they granting you a perpetual license, which allows you to commercialize it, what you create? Are they granting you a limited license where you're not allowed to commercialize it? Or if you do commercialize it, then you owe them a certain amount of money. Um, a lot, the only like pure way to like make a video game would be like if you went, created your own engine, created all the assets, and created everything by scratch, then you could purely own it. But we all know that's not really how the world works. That you're going to go use Unity, use Unreal, use Godot. So you are incorporating their copyright into your game, into your asset that you're making that you can sell onto the store. You're incorporating it. And since you're incorporating it, you have to abide by the license that they give you. And depending on the terms, that can dictate that can dictate a lot. Is that answering what kind of the question that you were asking, Andrew?
Yeah, and raising even more because, so I love the modder community. And of course, my holistic games are exactly what you just mentioned. It's our proprietary engine. We create all the art, we own all the art, etc. So we have a very fun modder EULA. And we could have a whole several-hour conversation just on what your EULA should contain in your game, especially if you're having modders.
Yeah, and it really it depends a lot on your kind of how you want to approach that, and kind of your attitude towards that. Like I said, like at the time, Blizzard had a very relaxed attitude towards modders. They encouraged it. They really thought it like built their community, and then the modders developed this whole new genre of game that becomes vastly popular, and does that once you were able to stand it up on its own 2 feet, didn't really need the Blizzard's copyrights anymore. Therefore, Blizzard wasn't entitled to any of the profits or any of the any of that money, and that really you saw. Then all of a sudden they changed all of their terms of service and EULAs to make it so that the next time they wouldn't lose out, that the modders are transferring those rights to Blizzard, and kind of forcing people to give up ownership, and that's a huge shift from where they were before. So the biggest thing to like take away is just if you're using somebody else's program to develop your game, or you're using even if it's what's known as Creative Commons, that those are all licenses, and you should understand what the terms of those licenses are, because you're going to be building off the back of it. I've advised major companies who have misunderstood what open source meant. Open source is again just another form of license, and they thought it was just free reign to go develop whatever they wanted, and that bit them in the butt, because like all of a sudden you go read through those terms of that open source license and it says you cannot commercialize what you're doing, and they are making millions of dollars selling a product that's built off of an open source software that doesn't allow for commercialization. So it's really important to understand those terms.
Yeah, we're definitely not going to talk about how that applies to live streamers right now. We're not going into that conversation.
No.
But
yeah,
I did want to point out how important this is for everyone. And this was, I mean, I knew the Blizzard guys back before Davidson and then during the Davidson period. And that was certainly their attitude early on, was they were very happy to see the community build. In fact, when I was doing the Vampire game, people were playing Vampire within their online services, and the Blizzard folks were quite happy with that. But then once it's Activision, there's a whole different attitude, and both are legally defensible, but only legally defensible if you've actually have the contracts in place.
Exactly.
So again, a lot of great information here from Andrew. And we put in caps. Don't overlook the bankruptcy clause. How to get your IPs back. Remember that my company HDI, we are still able to sell our games from the early and mid '90s because we got the rights back from companies like Sega and Take Two and others. So make sure you have those clauses in there. Talk to lawyers. Don't underrate yourself or these clauses. They can be invaluable. You can keep making money years and years later, as you should. So it's your work. It should continue to bring in value. Andrew, that was great stuff. Last chance for anyone in our Discord, YouTube, or Twitch with any questions. Ryan, I don't know if you had questions because you're focusing on animation as well. When people make animated shorts with your game, what you're going to do about the rights for those. But not seeing any other questions. Oh, there you go. Hey, Ryan. Oh. Ryan, if you're saying something.
Can you hear me? Oh, there we go. Yeah, sorry, I had my microphone. Yeah, we're going to be generating a lot of material. And actually, a lot of it's going to be done in Unreal. Even though we do have a regular animator. All that stuff, I think, is probably... I don't know. That's actually a really good question. I'm assuming we own everything we make within Unreal up to a certain dollar amount.
So it again, it depends on the contracts. So I've read through, it's been a bit, but I have read through Unreal's license, and you retain ownership over everything you create. The payment comes in terms of the amount of royalties that they are owed based off of how much you're selling. So, like, if you start selling more games, then they start coming by to be like, hey, you owe us some money here. But in terms of ownership over the IP that you create, you own all that outright. It's just, again, when you're developing a game, right, you could develop all these wonderful characters and, storylines and missions that people get to play. But then as soon as you rip out that engine, you still own that IP, but you can't, to all the, the stories and characters, but you can't utilize it because you don't have the engine in there, running the game. So that's why they believe they deserve royalties, is because they believe they're powering your game kind of from the back. So and so that's how they generally have it structured, is that basically they are giving you a license to utilize their copyright, which is the game engine. And if you hit certain milestones in terms of sales, then you start to owe them certain royalties in terms of how much you're selling, and based off of what percentage and what type of game it is. And so Epic does generally like to let people come in for free. They got a lot of Fortnite money. They I think have slightly better terms than I think Unity does, but Unity is also was a lot popular, a lot more people understood Unity. So it kind of pick your poison, really. I will say also be careful of, like, they can and this did happen with Unity. They can kind of update their terms of service at will. There's not a lot you can do about that. You can go to a different engine, but again, practically it's very difficult, I'm sure all of you know, to port your game into a different engine once you've basically built it up. So, but just be aware that they can change the terms if they want. It's kind of an unfortunate side effect of current contract law.
All right, lots of
Sure, yeah, that makes sense.
Ryan, you have any other questions or anyone else in our Discord? Really appreciate it. A lot of great info there, Andrew, and everyone can see on the screen, Andrew at PremackRogers.com, how to reach out to him. And I will send you my EULA just so you can have a good laugh.
That'd be great.
All right. Thank you, Andrew. Thank you, everyone, for joining tonight. Remember, coming up, well, first of all, support GGA games in the Steam Summer Sale, be it Lightbreak, be it Isometro, be it, well, you can get Killing Floor 3. I don't know if it's on sale right now, or Dead Zone, but also Emperor of the Fading Suns. Contact myself or Destiny to be part of the new Discord, where you can get your game its own channel and a moderated Discord channel. Remember that Saturday, Ghost Gaming is doing a play test, and we'll have the information up on our website. And then we're doing our August 12th GGA meeting at Ghost Gaming again. And September 9th at Tripwire, as we start getting ready for Siege in October. Andrew Thomas, thank you very much. Great information, and every game dev, and really most people need to be aware of this stuff. So, can I thank you?
Thank you. It's been a pleasure. I hope to come back and give another talk sometime soon.
That'd be great, especially if we can get you here in person here in the South. We'll drag you down here at some point for a dream hack or something.
That'd be great. Probably not in the next couple of months, having a baby, so that's gonna take a lot of time. But I look forward to joining you guys in person sometime. Sounds like you guys got a lot of good stuff going on.
Congratulations on bringing a new gamer into the world.
Thank you.
And one last thanks from YouTube, Medi from Lightbreak. Actually, hey, I didn't know you're here. Great talk. Thank you. All right, take care, everybody.